Well, let's address another matter of this. When we talk about the legal fraternity, how exactly are they viewing this case in regards to the sort of criticisms that tend to come in when we see cases like this, especially when it comes to not just X, also we've seen it in the past with Google and Meta. Now, criticisms have always come in connection with these cases about how it tends to decline our image on democracy.
See, first and foremost, you have raised a very tricky question, like, when you compare it with democracy. See, ultimately, what is democracy? First and foremost, it is free and fair elections. Now, I agree, free speech is essential to democracy. And this is where, another fundamental aspect comes in. Because obviously, I fully agree with you that in a democracy, you cannot tell the people what to speak. You cannot even guide them how to speak. Because, if you look at certain authoritarian regimes, there they actually, prescribe, no, people should speak in this manner, they should give this. But it is very important, as you said, because in one way, the government has to tread a thin line here. What the government should be, the government should be focused on doing its job, which is to prevent riots, to prevent criminals, and also to prevent obscene content from flooding the system. Government, because the day the government oversteps its mandate and starts saying, no, people should talk in this manner, people should speak in this manner, people should echo these views, then yes, you're right. Even though we may have free and fair elections, even though our elections are free and fair, there is no doubt about it. The only thing is, along with the core component of free and fair elections comes fundamental rights, right to freedom of speech, freedom to practice religion, and the other fundamental rights enshrined in Part 3 of the Constitution. So government has to tread a tightrope here.
This question to you then, Mr. Pratap. What kind of practices are best when we talk about social media platforms like X, the kind of content that is regulated there, when we talk about balancing freedom of speech, freedom of expression, and then regulating unlawful content?
Aware, government has a lot of computing power and tools at its disposal. Ultimately, what is Twitter? Twitter is a portal where people upload their tweets, where people express their views and other things. Obviously, the first step, what is the government's purpose? The government's purpose is that no radical content should be disseminated, no content which incites the mob, that should be disseminated, no content which is hate speech should be disseminated. So likewise, obviously a tool like Sahyog enables the government, because let's see to what extent governments use it. For example, is it possible for the government to screen each and every tweet on Twitter? That is something I'll put a question. Rather, to the contrary, the government would be scouting Twitter in real time. Twitter provides APIs by which the government can access the Twitter tweets and scan them electronically. See, ultimately, it's what? Sahyog portal might scan the tweets, it might screen the contents of the tweets, it might use AI and big data to determine which tweets are not. Then the government may perhaps, like there are people who are constantly prone to hate speech. You are well aware, I won't take names here, but there are lots of Twitter users against whom police FIRs have been filed and even cases have been filed. Probably the government will do a profiling of them and then selectively screen their tweets. So ultimately, whatever mechanism government deploys, whatever force government deploys, whatever legal regulatory mechanism, whether government uses AI or not, ultimately it is the instance of each exercise of that power that would be open to judicial scrutiny on the touchstone of Article 19, freedom of speech and expression. And because if you see Article 19 also says...
How does...
Yes. Because see, Twitter is not... See, yes. That's the best part I'll get you in. Twitter is an internet intermediary. Twitter is not publishing any of its tweets. So Twitter has no control over the content. Ideally, if the government, for example, deletes a person, if the government orders Twitter to remove a person's tweet, Twitter can notify that person, and it is up to that person to approach the appropriate court of judiciary, maybe the High Court or whatever, and say, please quash the government's order. It is hampering my freedom of speech. Because there's another question which comes here, because see, freedom of speech is for the citizens. A corporation per se might not be entitled to freedom of speech vis-a-vis a private person.
But that private person would essentially be a citizen as well, right? I do want to cut across to Mr. Aditya Pratap, an advocate who remains on the broadcast with us. Mr. Pratap, thank you so much for waiting. Considering you're going to be a legal expert on what's taking place, what is your opinion on the legal safeguards that currently exist to prevent any arbitrary, because that's the term also used in this case, or any excessive censorship under India's IT Act? And are these safeguards adequate?
Well, first and foremost, in my opinion, the law provides very adequate safeguards. We have the Supreme Court judgment in the Shreya Singhal case. And moreover, when we look at the facts of this controversy in question, we see a very distinct operation of Section 69A of the IT Act and the relevant provisions of Section 79 of the IT Act. As you can see, is that Section 69A of the IT Act and Section 69 of the IT Act confers the government upon the government to block powers, blocking of content. Then Section 79 of the IT Act basically confers internet intermediary powers. Because what 79 says, an internet intermediary will not be liable if he complies with the government directions for removing content, and if he has not initiated the transmission, he has not received, the intermediary does not control who is the receiver of the transmission, and the intermediary does not modify the content of the transmission. Now, if we see in this case, Twitter is not modifying the contents of a post in any manner whatsoever. Then Section 69 confers powers upon the government to initiate some levels of content blocking. And apart from that, Section 69 itself makes reference to safeguards. Now, as you're well aware, India's innumerable websites, the government has the mechanism to monitor the cyber sector, and the government constantly issues circulars and guidelines directing what content can be removed, what content cannot be removed. If you look at Sahyog, as you know, in the Internet, the IT Act, it is basically a regulatory mechanism. Sahyog is a tool which we can say is designed to sort of assist the government to regulate. Ultimately, how the government is to regulate, what administrative mechanism the government is to adopt, that would be, see, so long as the government's actions do not run afoul of Article 19 of the Constitution of India. Now, if you see the concept of Article 19 here, which is Twitter enables people to have freedom of speech and expression. Now, if we see, when people log on to Twitter, they give posts, they write content. So, of course, they are exercising the freedom of expression. Now, the main criteria is, if, see, Sahyog is a portal designed to, help the government identify tweets, find content which is offensive to the unity, the sovereignty and integrity of the country, etc. The actual decision as to what is offensive, what is not offensive, what is harmful to India's sovereignty and integrity, what is not harmful, each case has to be apprised on its own merits. It has to be apprised on its own merits, and that each particular thing. So I do believe that if Twitter has tried to challenge the government's usage as a tool as a whole, there would be some legal issues which will come up, because, whenever the government issues a content blocking order, you challenge that particular order, saying that, like, this is not offensive, please pause this order. You must have seen recently the Imran Pratap case. He recited a poem on stage. Government lodged an FIR against him. Immediately, the Supreme Court quashed the FIR because they said the contents of the poem prima facie do not reveal anything which is outrageous, which is inciting a mob, etc. Likewise, each time the government uses the Sahyog tool, that each action of the government would be subject to judicial scrutiny. So I do feel that, because, see, ultimately government has prescribed safeguards, so long as the Sahyog tool falls within, because ultimately, see, prescribing safeguards is the domain of the government. Because ultimately it is delegated legislation. Sahyog itself is another exercise of the government's executive power, the delegated power. So ultimately, each time the government uses Sahyog, whether that particular instance of usage complies with Article 19 or not, or whether it offends the freedom of speech and other things, that is something which will have to be taken into account.